Science teacher cannot display religious material in classroom. School district's termination of Mount Vernon teacher for insubordination is legal. John Freshwater v. Mount Vernon City School District Board of Education. Case number 2012-0613. 5th District Court of Appeals, Knox County.
Is insubordination amounts to keeping his personal Bible and the poster of the president and his cabinet in his room. Plus, he went to the library and got another Bible and a book about Jesus and put them on the lab table.
That's correct, Your Honor.
And that's the insubordination.
That's correct. A Bible on a desk hidden amongst teacher clutter does not a religious display make.
This is really a hybrid case. This is not only a constitutional case, but it's an employment case. And you're asking us to reinstate the teacher.
Well, Your Honor, it would still leave open to the board the opportunity to give Mr. Freshwater whatever clear directives it wants to offer.
We owe the board no deference, then, you're saying?
Where censorship and erroneous conclusions of law, such as that providing evidence of gaps in evolution equals religious indoctrination, that is the type of anti-religious hysteria that absolutely does warrant complete de novo review.
I know you talked about abuse of discretion with respect to the magistrate's materials in the court, but what about our review of what the board did here?
The standard of review for the appellate courts is the abuse of discretion standard, where there must be evidence of not just errors of judgment, but perversity of will, passion, prejudice, partiality, moral delinquency, maliciousness. Also, when there is much conflicting testimony, this court has said, a reviewing court is to defer to the referee's findings even more so. This is not a de novo.
Although a public school district violated a middle school science teacher's First Amendment rights when ordering him to remove a Bible from his desk, the teacher's firing was valid because his refusal to eliminate other religious symbols from the classroom was insubordination. The Ohio Supreme Court ruled on November 19, 2013. The court was limited to reviewing the lower court decisions for abuse of discretion. Those courts did not err when they determined that the Mount Vernon City School District Board of Education had good and just cause to terminate John Freshwater's teaching contract. Chief Justice Maureen O'Connor wrote in the court's lead opinion, because the case was resolved by determining that Freshwater was legally fired for being insubordinate, it was unnecessary for the court to address the issue of whether he was unconstitutionally injecting his personal religious beliefs, including creationism and intelligent design, into his science class instruction. The decision affirms the judgment of the 5th District Court of Appeals, the Common Pleas Court, and the school's referee in the matter.